All right. So I'd like to thank you for being here today for the Copyright Working Group's Masterclass Series, Interlibrary Loan. With us today, we have Melanie Poloff, Manager of Interlibrary Loan, and Kim Preston. I'm sorry, I don't know your official title.
Assistant Manager.
Assistant Manager. Okay. All right. So they have a PowerPoint today that they'll be presenting, and they'll be presenting how copyright applies to interlibrary loan. The slides will be available along with the recording after this is done, and this will be available through the Scholarly Communication Toolkit LibGuide, which I'll give you the URL for later on. If you have any questions, you are welcome to ask your questions in chat. I will let Melanie and Kim know if they have any questions. So, all right. So with that,
thanks,
go
Kristen.
ahead.
All right. I'm going to get this going and share my screen.
And I will talk a little bit while she's getting the screen up already. Kim and I want to thank all of you for taking the time to join us today as we talk about ILL and copyright and how to balance the needs of the patrons with the needs of the publishers. The two of us find it fascinating, interesting. We don't necessarily expect you to find it as fascinating as we do, but we do hope it'll be at least thought-provoking and at least a little bit interesting. I can start talking a little bit. Ken's on here, and Ken used to be head of ILL, and he can tell you back in the old days, in the before about 1975 or so, if you wanted something from another library, you would call them up on the phone. You would send a nice letter with a slip in the actual U.S. mail, and they would send something back. They would send you the bound journal. They would send you the journal issue. They would send you the book. It was just really straightforward and easy. And then, go ahead, do it. Oh, let me do this. It is a disclaimer. As I say on Reddit, we are not an attorney. We're not a lawyer. If you have any real legal questions, talk to legal about it. Go ahead. So is copyright really important to ILL? Yes. Every single day, every single borrowing request, we have to deal with it. And it became so important, as I said, all because of one invention introduced to the public by Xerox in 1959. Boom. And that, of course, is a photocopier. Beforehand, like I said, you would just mail people the actual thing, but then you had this machine that you conceivably could get a whole entire library and make copies of it and give it to people. And of course, the publishers didn't like this because they weren't making any money from it. So basically, Xerox, in a way, gave birth to the Copyright Act in 1976, which of course is the foundation of the U.S. Copyright Act. Law. I know Larry did an excellent job, and Tom has, describing this in detail. So we're just going to kind of touch on it a little bit. But of course, the Copyright Act in 1976 talked about fair use and, what is copyright, when isn't a copyright. You can do it. So because of this, they had to come up with certain issues with interlibrary loan and how the copyright fit in it. So then Cantu came into existence in 1974 to kind of talk about these rights and this balance. And it's the commission, it was the Commission on New Technological Uses. These were guidelines. They weren't laws, and they still are not laws that were developed after the 1976 Copyright Act was enacted. And it technically is a gentleman's agreement. And as Kim and I said, it basically is 95% a gentleman's agreement. It was all these publishers got together, and people in the government, people in libraries, set rights holders to decide what can we do. And the main takeaways of the Cantu discussion was what we call the rule of 5, or the suggestion of 5. Again, is not the law of 5. You have 5 copies allowed from the past 5 years from any single journal title. And each photocopy request must also contain, you'll see the copyright notice in a bit, it'll have complies with copyright guidelines or complies with copyright law. And the borrower includes this notice, the lender checks for it. And if we get something in for someone that doesn't have it, we're supposed to add it. And everything, we actually have it set up in programming. Anything that gets sent out has this. The lender includes with a copy, the copyright statement, as I said, from the work itself. And this is the notice that goes out. When I've worked other places, everybody does it. A lot of copy machines, any Xerox machines around the building, public libraries, and the courthouse, lots of times we'll have this above it also.
We also
Again,
have it on our webpage.
Right, exactly, yeah. It is a borrowing library who's held liable for copyright infringement, not the lending institution. If, say, FSU wanted us to scan a 15-volume set book that was published last year, if we were insane and wanted to do it, we totally could do it. We wouldn't get in any trouble. But the borrowing library, FSU, they could be fired, they could be sued, etc. So the onus for this is on the borrowing library, not on the lender. And everything that came out of the 1976 Act and the Cantu and everything specifically for lending library, for interlibrary loan is the United States Code, Title 17, Chapter 1, Section 108. And we would just call it going forward 108 or Section 108. And again, this is specifically for making a reproduction, which I mean, would be Xerox. And I do want to make a statement, and Kim will talk about this more later. It basically was just for Xeroxing. I mean, we were still quite a bit away from, any kind of internet. It was around then, but just the military had it. Fax machines weren't really being used that much. So, it's a very, very narrow focus of, that really needs to be, I mean, and I know some things have changed, but there's an awful lot that hasn't ever been covered yet. Go ahead. Okay, so what does 108 do? It attempts to balance the interests and needs of both publishers and libraries. And as anybody here, we've all done contracts, we've all done a licensing agreement. Licenses trump the law. It doesn't matter what the 1976 copyright law says. If we make an agreement with Taylor and Francis or someone else that says you can't do this or you can do this, that trumps the law. Whatever's agreed upon in a license supersedes the law, Section 108 Cantu, though that's not the law, but still. If the license is silent on ILL, then you refer to the law. Read and be able to refer to your licenses so that you know what's allowed for a particular publisher or publication. If anybody here ever has a question about that, you can, Maris and Don Frood would be the best people to ask. We probably can read it for you because we do have access to it. But if you want to get into the nitty gritty, Maris would be the person to ask. Who enforces this? The Copyright Clearance Center. We all probably know about that. We've all worked with it. Copyright Clearance Center is a really interesting history to it. It was originally supposed to be like a quasi-governmental agency that was the watchdog that protected fair use, that protected the libraries, it protected the public, and it protected the publishers. But they collected a 15% commission on any of the copyright fees it collected. So, when money comes involved, some people sometimes help the people with the money. I mean, because they still do provide the licensing service, et cetera. Well, what happened is they have their tax exempt status pulled in 1982 because they were no longer really a impartial watchdog. So now they, of course, are a company that will act as a co-plaintiff with publishers to come after libraries and other people who they think aren't paying them their copyright fees. And we'll talk about that a little bit more later. What happens if FILO ignores these guidelines and laws? You could technically go to jail, but you're going to wind up in a courtroom.
Yeah, it's more like that you'll get fired.
Right.
And it will be us, and you'll be sued. It's not necessarily that you're going to go to jail, but we like our jobs and we don't want to get fired. So yeah, one of the big cases that you come across, and most people know about it, is the Cambridge University Press versus the Georgia State, which was Georgia State made a large volume of works available on their eReserves, and the Cambridge University Press sued. They said that they alleged that it allowed people to view, print, and download without the permission of the copyright holders, and they were seeking to limit the unlicensed use because they felt that it was threatened the incentive for the people to produce. So they believed that by doing this, they were de-incentivizing people to produce and publish because they weren't getting their copyright dues. And that being educational was not enough of a justification for this case. Now, Georgia State won the case. They found overwhelmingly that the uses were not infringing. I believe it was something that of the almost 7,000 instances that they were trying to allege were violations, I think they found 4 that they said could be considered violations. Now, this is reserves, but it is resource sharing, and ILL is like its cousin. And, you know, it's good to keep up with what's going on. This was a case where Georgia State said, no, this is fair use. We're going to go ahead and we are going to do this. And that's something for us to look at. We'll talk about it later as, you know, interlibrary loan on practices that we have right now. Another part, public domain and fair use is very important to filling ILL requests. In 1998, there was the Copyright Extension Act, which is commonly, you know, called the Sonny Bono Act, and also called something else, but I'm not going to say that. But it basically extended the term for when things were going to fall into public domain by 20 years. So things that were published in 1922 were in the public domain January 1st, 1998. However, with the extension, things that were published in 1923 did not fall into the public domain until 2019. So this is important for us because when we get requests for things, we always look to see if things are in public domain, can we fill it with, if there's an online, you know, scan of it, can we go ahead and give that to them? So knowing when that line is important. Also, fair use, one of the cases that both Melanie and I found interesting, so that's why we're mentioning it here, but it actually does, you know, have some applications to ILL, is Harper and Row versus Nation Enterprise. Now, the Nation was, I believe, a journal that did a story, and it was on upcoming memoirs for Gerald Ford. And in it, they quoted about 300 to 400 words, basically on Gerald Ford's decision to pardon Nixon. The publishers sued, and they said that this was not fair use, and that they were basically limiting their ability to make money, because I guess they were saying that's the only interesting thing, and that's the one thing everyone was going to be, you know, interested in, and here you have spoiled it. They did fine for the publishers. So in interlibrary loan, you know, we have to make judgment calls about how much we're allowed to fill, you know, like volume, either for the journal or the issue or the book. And in this case, this was only 300 to 400 words out of, I believe it's something like 500 pages, and they found for the publisher. So that's something to keep in mind, is that it's very subjective, like each case is different. Now, this case was in 1985. Melanie and I think we've discussed it, and we both think that it may be different. I think they might find differently now, because we're kind of like a hashtag spoilers, you know, thing with the internet. You know, the idea that a small excerpt that was published is, I think things may be different. But these, besides the Copyright Extension Act, most of the information or things that we have to go on is litigation. It's fair use cases. There really hasn't been updates to the copyright, except there was the Digital Millennium Copyright Act. There was one paragraph that I'm going to get to in a sec that was specifically about ILL, but this was more ratifying basically a world international copyright, which the World Intellectual Property Organization, which was about the criminalization of circumventing access. So this was in the 90s. This was right before you had started having the cases against Napster, and file sharing and things. So this was about digital rights management, and it was basically criminalizing, going around and giving access. It also exempted the internet service providers from liability. So, Google or whatever, that it just like, the telephone companies for wire fraud, they're not liable. But there was one paragraph, one section that was specifically acknowledged that we are now in a digital age. This is the actual paragraph. Basically, in the past, we were allowed as libraries to have a copy, of actual physical copy for sending for interlibrary loans, or for rare books for preservation purposes. And in here, it acknowledges that it is legal and it is our right to have a digital copy. So we can now have digital copies in our catalog, and we can send a digital or PDF file as interlibrary loans. So this was already starting to happen, but this made sure that now it is legal. All right, so what does this all mean for the day-to-day operations of interlibrary loan? Well, the challenge for us is that we obviously want to, stay within the legal bounds. We follow the guidelines that is pretty much the standard currently, which is CON2, for providing interlibrary loans. But we also have concerns of costs. So how much it costs to either borrow, and then the copyright fees. And we have to balance that with actually filling our patrons' requests. So it's things that we're juggling to, A, we want to keep within the bounds of being legal. B, we don't want to pay a lot because we don't have the money. And 3, we really want to fill it for them. So Melanie talked about earlier briefly, CON2, one of the main things with CON2 is the rule of 5. Now, the agreement is that if it's older than 5 years, we do not have to pay copyright. If it was published within the last 5 years, then the first 5 requests in a calendar year, we do not have to pay. The 6th and everyone after, each one, we have to pay a copyright fee. And I want to make clear, this is the whole FAU institution. This is not just one person. So if one person puts in 5 requests and somebody else puts in, the next day for a different thing, they would have to pay. Now, we do subsidize currently for grad students up to $12 and for faculty up to $25. But anything over that, it would be then on the patron in order to pay, because we can't pay more than that. The other main rule that we have is the rule of 2, which is part of 108. Basically, this says that libraries can provide 1 article per issue with the patron without requesting copyright permission. After that point, for the second and each additional one, we would have to pay the applicable copyright fees. Okay, so day to day, when we have a borrowing request come in, one of the first things we do is we have to see, okay, do we have access to it? Is it in our databases? We look online. Is it public? Is it in the public domain? Has the author put it out, on ResearchGate or some other site? Is the university that it was published through, do they have it, freely available? If it does, great. We cancel it and we let them know that they can go get it. And then we don't have to be worried about the copyright. When we're looking at the request, we have to see how long it is. Like I said, you could have an issue and it only has 2 articles and each one is like 70 pages. So then we have to decide, okay, that's literally half of the issue. You know, is that covered, or should we try and get the loan? We also have to be concerned that each request we get in is only one article or only one chapter. We can't have, you know, chapter 3, 4, 5 all on one request. We have to have them separately under the guidelines for Con2. We also have to check, we have it integrated into our ILLiad program, but we check to make sure that for this year, we are within the rule of 5. So how many have we had? You know, is this the 6th one? Is this 7? You know, okay, then how much is the copyright charge? And then from there, we have to find out whether the patron will need to pay something or whether we can cover it. We are also have to, like Melanie said, we have to mark it when it goes out, whether it's CCG or CCL, whether it's within copyright guidelines or copyright law, which is less than 5 years or more than 5 years. So because part of Con2 is saying that we have to, as a borrower, and then the lending library has to see that it's marked that we are asserting that we are following Con2 and the copyright law. Final concern would be international copyright. We are still bound by international copyright as well. And the best example of that would be the German copyright law. They do not allow for the electronic to send PDFs. So and we do have a couple of professors who they get a lot of things that we can only find in Europe or in Germany. So we request it from them, happy to do, but they will print out a hard copy, photocopy, and mail it to us. So we have to know that we can get it, but it's probably going to be a couple weeks because it's going through international mail. And so it's things like that we have to be aware of when we are dealing with international libraries, that we are also following whatever their copyright laws are in a reciprocal manner. Now, Melanie said earlier that the borrowing library is the one that is liable. Well, that's true, but even as a lending library, we try to follow it, and we also come up across copyright things. Excuse me. Next page. Copyright issues on the lending side. One of the big ones would be embargoes. That's part of the licensing. We have had some interesting embargo lengths. I know that there was one journal that we had that was literally embargoed for 78 years.
Mm-hmm.
Now
we had another, through another database, there was only embargoed by like a year or two, which the standard is a year or 18 months is the normal one. But we do have some where the embargo might be for 4 years. So that was a technology journal, which is interesting. It's 4 years anyway. So we don't have access to that. So we need to know the embargoes so we can see whether or not we have access in order to fill requests for other libraries. We also need to know for licenses, Melanie mentioned earlier, Taylor and Francis. Well, up until I think it was what, 2013?
Yeah, it was just like a year or so before we started.
And right before we started, part of their license was that we could not fill or send the articles that we downloaded from Taylor and Francis via PDF. So we had to fax it in 2013. So that April and Holly will tell you that they spent hours sometimes faxing things to the other libraries that we had downloaded and printed in order to fill their requests. That was a little time consuming and not great, but we had to follow it because that was part of the license agreement. Another thing, basically this would fall under the fair use. So gray papers, GovDocs, rare books, thesis demonstration, the public domain. These are things that we look at and we see if we can go ahead and either scan or download the whole thing to send. Like if it's our dissertation and it's only online and we're the only holder, the idea that, you know, you can't send the whole thing, or no, we can send the whole thing. That is if considered a fair use, and we can go ahead and do that. That's again why it's good to have an idea of what items, you know, fall under the public domain and the like.
Kim, I have a question.
Sure.
Could you define gray papers for those who might not know what that is?
Okay, we have a they basically
it's like reports, annual reports, research, technical things. They're not books, they're not journal articles, they're not book chapters. So it's in a gray area. It's like gray literature.
So it's kind of like that's not a scholarly publication, but
it's like scholarly adjacent might be a better way to put it.
Well, like we have, this is mostly HBOI. We have a lot of papers and literature and reports. So it might be some survey done, you know, oceanographic survey, and we are one of like 5 holders, supposedly. They have a lot of specialized information. And because they are rare, and a lot of that stuff is government document types things that we can go ahead and scan or loan those out. I mean, I've got requests from, you know, the EPA, NOAA, NASA, you know, a lot of government institutions have asked for things from HBOI.
Not just in the US either, like Australia, New Zealand request a lot of stuff from HBOI.
Yeah.
Okay, thank you. Thank you.
Sure. And then part of Con2 is the agreement is the copyright notice. So every request we send out or every request we get in, we have to see that they have a copyright notice. So for example, when we scan, we have a little, basically a little piece of paper that has, you know, the general, we follow the copyright and we make sure it's on the first page, taped on, so that when we scan, you can see it. It's on all the documentation, it's on the request. And we're looking for the borrowing library to also say that they are following copyright, and that is part of the Con2 agreement. So
now I'm going to talk briefly about ILL in the time of the pandemic. So there's a private Facebook group for ILL folks globally, not just the US. We weren't even closed yet when everybody was in the group talking about what can we do? Everybody's closing, and not just here, across the whole entire world. So, you know, we discussed earlier how Con2 is woefully archaic and inadequate now. And we already knew that, but the pandemic has really thrown like a spotlight on what the issues are. And again, it's not law, and everybody's so afraid of it. Everybody's so afraid not following it. And, you know, if you don't follow it, you're not breaking the law, you're breaking a convention, you're breaking a tradition, basically. But everybody's like, we kind of have to do that now. We just have to give people what we can give. And so some of us started doing that. And some people, not us at this point, are still doing that. They're like, we don't care about this anymore. It's stupid. And they're just doing what they want to. So there's a lot of talk now in ILL circles about Con2 needs to be scrapped. It just needs to be getting rid of, and the copyright laws need to be improved so it's codified. Go ahead, Kim. So one thing, and this is thanks to Maris and Dawn Frood, have helped. HathiTrust. If you don't know what HathiTrust is, it's a huge digital library. We've traditionally, before the pandemic, used it for like certain book chapters, a lot of old newspapers and things like that, everything that's digitized. So they kind of got right on the stick and started joining with everybody, ILL, and creating agreements. I know that Maris has an agreement with them. Go ahead, Kim. And right now, we have, it's the partnership. Well, this is just the regular thing right now. It's all these research libraries across the whole world digitize and put things up. And the costs are shared by anybody who's part of the HathiTrust Trust, just like we are. And they have also had their share of lawsuits. Their biggest one is the Authors Guild versus HathiTrust Trust. And it was, again, publishers not happy that they were making things available for people to use for fair use. Well, HathiTrust Trust won that. Again, just like Kim and I said, to move things forward, it seems like it has to be litigated. And when it litigates, judges don't always find for the non-publisher, but they often do. Again, as of 2021, their copyright policy states that many works in our collection are protected by copyright laws. So we cannot ordinarily publicly display a large portion of these protected works unless we have permission from the copyright holder. And thus, if we cannot determine the copyright permission status of the work, restrict access to that work until we can establish its status. Because of the differences in international copyright laws, access is also restricted for users outside the US to works published outside of the United States after and including 1896. But that's changed now. They have opened up so much of their stuff, and there's all these agreements right now. The thing, I mean, you can see it's almost 18 million volumes are digitized by the trust, and FAU holds almost 5,000 of those. If you go into the catalog now, it's especially heavy in history and some of the other categories, subjects. But if you go in and you see a book that we usually hold, that's a hard copy of a book. It'll say temporary access. We cannot lend that out to anybody, not even our own folks. But you can go in there and you can pull up the digitized copy of the book and you can read it. You can't download it, you can't print it, but it's available. So instead of just having one copy to give to somebody, people all over the world, well, FAU world, you know, can go ahead and go in and use it. You know, I'll be the first to admit sometimes that some of the history folks haven't been happy about it because we have to get things out on, we have to borrow things. And instead of just being able to give it to them on a Monday, it might take them 2 weeks to get it. But again, more than one person is able to use it. And right now, especially with remote work, remote classrooms, it's been great. So that's what's going on right now with ILL. So what's changing? And Kim's going to talk about ILL, copyright in the future, the battle of copyright.
Right. So COVID and being at home and having libraries shut, like Melanie said, has kind of thrown a light onto some of the issues with copyright, because the debate on, you know, especially things like ebooks and how we can we loan them? You know, before the law was saying no. So really a lot of people are debating this and looking at it moving forward on what copyright for interlibrary loan, what it really means. Come on, there you go. All right, so for the day-to-day, what we're already doing, one of the big things is the push for more open access. More things are in the public domain or open to everybody. We don't have to worry about copyright, you know. So continuing to push for open access from an ILL perspective is very important. We will have further reliance on services like OCLC Express and Reprint Desk. Those are ones that are the copyright's already kind of bound into the cost of getting it per article. Again, we're pushing those costs onto our patron and denying filling it. We don't want to, but we don't have the money that we may have had in the past in order to fill things. But one of the things that we can do is foster reciprocal relationships with other libraries. Like we have built a really good relationship with the Royal Library in Denmark. And so they agreed, you know, we won't charge them, they won't charge us. However, if there's a copyright fee, then we have to cover the copyright. But the more relationships we have where we mutually decide not to charge any fees, because we charge, you know, if we don't have a reciprocal relationship, it could be $15, $25, $40, depending if we have to invoice per request. So that would be not including copyright. So if we can have more reciprocal relationships, which we are active in trying to do, then the only fees that we have to really be concerned with would be any copyright fees. But that's just kind of basic day-to-day that we have. What we really need is an update, both in the law and with CON2, the guidelines. It's been decades since there's been any changes. In the CON2 was originally, came out in response to, after the copyright law in '76, because it was very vague. So that's why the groups, got together, the publishers, the library, the Librarian Congress was involved. They all kind of agreed, these are, if we follow these guidelines for CON2, will be within the limits. But it doesn't address things like ebooks or streaming and social media and all these different new digital technologies. There are those that say that because the law is vague, that it can be applied, but the only way to do that is through litigation. That's the only way we're really going to find out, is if there are cases that go before the court. But for example, like CON2 came out in 1978. In 1980, they added the word computer to the guides. In '94, they tried to have a minor update at the Conference for Fair Use, or CONFU. And basically it was talking about, like media clips. So little things, video or sound, and whether that would be fair use. Unfortunately, there was no consensus, and none of those measures were adopted. It's not part of our culture in ILL as CON2 is. The current law, Section 108, uses archaic, antiquated language. I mean, they use the word phonorecord, which doesn't really fit anymore. It has nothing to do with how things are held now with the digital world. And then the final thing we kind of want to spotlight, there was a white paper put by the Association for Research Libraries last August, and I would recommend. It's a really interesting read, called The Modern Interlibrary Loan Practices, Moving Beyond CON2 and the Guidelines. And basically, I'm going to quote, and they were saying that CON2 was established based on an economic analysis of scholarly publishing, library acquisitions, and interlibrary loan arrangements in the 1970s. And that CON2 is outdated and should no longer be relied on as an appropriate measure of when ILL borrowing exceeds this statutory exemption. And basically, instead, we should be relying on principal determinations. They recommend that we should engage actively with the Interlibrary Loan Department, the library, and various libraries together on what the actual permissions are, what the law says. They advocate putting our trust in, or looking to the law as opposed to the guidelines, which have no legality. It was just an agreement for CON2 to base our policies and procedures on. So they recommend updated and flexible, more appropriate standard grounded on the text of the law, not CON2. For example, some ILL transactions could actually be justified not through 108, but through 107, which is fair use. So things that we may have be looking at from an I-108 CON2 perspective, to adjust our thinking and say that, no, we can do this like fair use. I mean, that's kind of what the Georgia State was doing, is they looked at it and like, no, this is something that we can do, and we're going to do it because it is fair use. Now, in the article, they talk about how CON2 came to be and basically what they were thinking, where they're coming from. And from their perspective, in the 1970s, the subscription costs were low, and they literally pretty much say that they don't see the need, that there'll be a need for ILLs, as you will have the journal, because even if it's a low use, you'll still get the journal and have it on your shelves. So that's changed. They had a chart where they were showing the difference in how much things cost for generic journals. One of the interesting ones was a generic physics journal. They said the cost for in 1978 was about $100, which in today's money would be about $400 some dollars. But the actual cost for this quote unquote general physics journal is $4,800. So that's a little different. The ILL cost per article, so that's not copyright, just how much it costs to get filled. In today's money, it would be about $37 back in 1978, but in actuality, it's more like 43 to 48 on average for what people charge. And then the copyright fee back in the 70s, in today's money, would be less than $5, and now it's anywhere from 10 to 38. And I can say that some of these science journals are very pricey, for copyright. So basic.
And I want to jump in on that. They are very pricey, and we do everything we can to build these agreements, to have, Maris and her folks to have, to create these licensing agreements too. Sometimes we lend stuff to people just so we know we'll be able to ask them for something later. When I took over this department, that like extra tack on copyright fees we had to pay out of pocket every year was almost $2,500. This past year was $142. So if you work at it, you can do it, but it does take work, and building the relationships, just like Kim said, to try to do it as cheaply as we can.
And unfortunately, while some of that is that we've had to turn people down, and because we can't pay for things, or
it's not available,
it's not available.
Yeah.
So basically, the white paper, part of that is with the license agreements. In a lot of the license agreements, it has in there that we will follow Contu, and that we will only loan to people who follow Contu. And their recommendation is to have that language removed. That it's not, so that we're not necessarily bound by that, or add a provision saying that we can use fair use.
And I can tell you from the Facebook group, there are people starting to do that. They're striking it out. And if the people that they're have this licensing agreement says no, they're like, just too bad. And they are changing the language. You just have to push a little bit.
Yeah, so basically what they're saying is that things like the rule of 5, Contu. 5 is an arbitrary number. It's not the law. That, the 5 years, why is things more than 5 years okay, but the last 5 years we're paying copyright? That has nothing to do with law. That was just an agreement that, we've come to, and it's now become kind of the standard. And that legally we may be justified in doing more than that. And that's something that, as interlibrary loan, the different across the country come, start trying and say that no, there is justified, because you can have a science journal that has, over the course of a year, 1,000 articles. In each, a couple articles are only 2 or 3 pages, so you have 5, and so that's 10, 15 pages out of 1,000. As a maybe for a book, yeah, that makes more sense, but for a lot of these journals, because it talks about the aggregate quantities. Doesn't define that. It says it's not, ILLs are not supposed to be a substitute for a subscription or for a purchase. But, this rule of 5 and Contu, it's what we've been using. But I think one of the best things that they said was that the farther you get from the 5, the more likely you're past the exemption. So, but we have to understand that we may be able to legally have the right to film more without paying copyright than we are now, because we are following Contu. So that's not just us, but that's as a field in interlibrary loan that we need to start looking at, discussing, And I think it's going to take, some of the big universities or doing like Georgia State did and starting to do something different. And then they might have a lawsuit and then it'll go and be decided in the courts. Because right now there really isn't any legal.
I also think if one big person did it, like Harvard or Duke or Stanford, UVA, I said, we're not doing it anymore, I think it would have a big domino effect and something would start happening outside of the courtroom. That's a possibility. But like Kim said, we'll have to see. And FAU is not going to be the one to do it.
No, we like our jobs. We do not want to get fired or get sued. But I think, again, one of the big things is the more push for open access. The more things are open, the less we have to have the concern with making sure that, with copyright, because we'll be able to provide it without any concerns about whether it's legal or not or having to pay fees. But that's mostly what we had. However, pop quiz.
We hope you all have been paying attention because you're all going to be graded on this and your supervisors will be told what your grade is.
That is correct.
That of course isn't true. I'm like totally lying about that, but we do have a pop quiz. We're just going to go over a few scenarios to just see what we have every single day. Just a few things we have. Course reserves have a few things similar that they have to deal with too. So,
all right. So for the first one, a faculty member has requested 7 articles from Volume 5, Number 1 of a journal published in 2010, which constitutes the entire issue. The library has a current subscription to the journal, but it does not begin until Volume 5, Number 2. The library has tried to purchase the issue, but it is not available. May the library request the issue from another library and reproduce it, or is the library restricted to 1 article from the issue as permitted under the Interlibrary Loan Guidelines? Could the library request all 7 articles from different lenders and pay royalties on 2 articles that would exceed the ILL suggestion of 5?
Does anybody want to take a stab at it? You don't have to, but does anybody want to show how smart they are?
Yeah, go ahead and use the chat for your answers too.
Yeah. Bueller, anyone? Bueller? I'm aging myself, aren't I?
So Cantu allows five items from a journal published not within the last 5 years or before that. Was it previous?
The rule of 5 is the current. Well, it's 5 years starting with the current year.
Okay.
So it's rolling.
Yeah, right.
So 5 years
rolling. Yeah.
passed from today.
Yeah.
So anything older than that, we don't have to pay copyright fees.
Correct. We do have the answer. You can go ahead, Kim, so they can read it. This one's a long one. Oh, Laurie Rebar. So we're past the rule of 5. Here we go. So unfortunately, this is not a replacement issue since the library never had volume 5.1. Our subscription started after that. Therefore, it doesn't apply. And we can't go ahead and just copy the whole entire thing. So, go ahead, Kim, and finish.
Okay. Number 2, a library has a current subscription to a journal, but does not have the 1953 volume. The library has received 4 interlibrary loan requests for the same article from the 1953 volume within the past year. Should the library refuse the 6th request or look into purchasing the volume?
Wow.
Laurie put something in chat a little while ago, which I think will go with this. Okay, so, it's definitely older than 5 years, so we can use it. And at this point, it might even be in the public domain if they didn't renew their copyright. Now, as Kim said earlier, sometimes you have these weird journals that have embargoes of 70 years, 80 years. So if we have that of course is licensing, and so that we have to adhere to that. But the odds are, nah, we can do it. It's fine.
Okay. A public library has an interlibrary loan request for a dissertation from the University of Wisconsin. A librarian found a PDF copy of the 26-page dissertation on WorldCat, which the library accesses through a license. May the library print the dissertation for the patron and charge to him the patron's standard printing charge of 10 cents per page.
Okay, so just forget academic, put in academic. This happens all the time with us. So anybody want to try it, chat it, or Christy talk or whatever?
I'm wondering if it would have to do with the license that may be attached to the thesis that University of Wisconsin may have for it. That's the first thing that comes to my mind.
The authors of a dissertation can sometimes claim copyright on it as the author rather than it going to the institution.
That's true too. Absolutely. Yeah. So go ahead, Kim. Pasha. So this is things they can do. What Christy and Kembo said can also apply. They say what one of the solution is, and what Laurie just said in chat, the author could have an embargo in it. Sometimes that happens. They're like, no, you can't have it. Sometimes it's 30 years ago and they say, no one can have a copy of it. That's bizarre to me.
Yeah, because if you do the research, wouldn't you want people to be using research?
So it's so weird.
But okay.
But the thing is said, there's another solution. Provide the link to the user and let them print it themselves. That's what we generally do. It's fast, it's free. We send them the link, boom, it's taken care of. And we don't have to worry about any of it.
Something similar is the site ResearchGate, which a lot of professors, or researchers, they will put their own work up. So it's the author uploading it to this site for you to have the download. In this situation, we can point them to where they could get it, but we're basically removing ourselves from it.
What Michelle Akiba just said is also true. Sometimes that they're holding it back because they want to go ahead and do their own research, maybe publish a book or something like that. And that's true too. It can be sticky and gray because all these different things. So if there is a link to a PDF, we give it to them. One of the first things we do for certain things is we always research Google, because sometimes there's a PDF. Sometimes, the author of an article or dissertation or whatever will have it available on their website for everybody. You just never know.
Yeah, or sometimes it's purely available from the publisher. I know right now with anything COVID related, a lot of publishers, any research and journal articles that they have, they're just putting it out there, so people can see it. So
Laurie Rebar just made a point. Lots of times ResearchGate, it is not the published form, because if it's the published form, the author might not have total control over it. Some people don't care if it's the published form.
Yeah.
Some people have to have the published form because sometimes, it's been vetted a different way. There's been editing and everything. So, it just depends. And in that case, we will contact our patron to ask if they'll accept a pre-publish.
Yeah.
Article or book chapter or whatever. It depends,
Okay. When an academic library obtains a copy of an article for a user through interlibrary loan, may it place an electronic copy of the article on a password protected website for the user to retrieve, rather than placing a photocopy of the article in the campus mail or emailing it to the user? If so, how long may the library leave it on the website for retrieval?
Okay. Any answers?
I've made ILL requests. I know the answer to this one, so I'm not going to say.
Okay. Yeah. Laurie Rebar got it right too. So go ahead, Kim. So yeah, this is what we do. It's basically a Dropbox that you put a password in. 30 days, again, that's what most people use, but it is arbitrary. Just like Kim said, it's not like a law that says you can't keep it longer than this, because there's nothing in the law that really kind of says that. Yeah, like I said, the rule of thumb is like 3 to 4 weeks, and we keep it up for that long. Also, it's good because, as we all know, patrons will print something out and lose it, or they download it and they can't find where they download it, so they need to go back in and pull it up again.
So we should mention here that when we fill a request, it's just for them. It's not for further dissemination. Right.
So then this example that you had just listed here about the password protection, it's not really, the law doesn't dictate that really.
Correct.
Yeah, the law just says that we're allowed, like the only thing that it talks about digital is like the DMCA,
Right,
where
right.
it says that instead of having, you have to have like a photocopy, or you're allowed to have, it says you can have a digital copy.
That's just for
Basically,
patron
that's it. But
privacy.
it doesn't say anything
Yeah,
about
yeah.
how long or
Yeah.
the dissemination.
Yeah, we do the password. That's for patron privacy, really. Yeah, I mean, because it's their request more than anything.
I think I just answered this one.
Okay, go ahead. Well, then I'll let you do it.
Yeah. In a nonprofit research institute, can a researcher send a PDF of an article that the institute purchased to multiple collaborators on a project? It is to support the work on a project, which I think I just answered.
Yeah, just basically answer. That's okay.
I got ahead of myself.
That's all right.
Yeah. So basically, when we get the bill, so book chapter article, it is only for that person.
Right.
What they do with it, they can download, they can print, they can save it, they can do whatever, but it's only for their use. It's
Right.
not for them to then disseminate to other people. Now, if they do that, that's not on us. It's their liability. So just like we have the copyright notice above the photocopier, if they still copy the whole book, that is, again, is not on us, but we do have the information in on our websites and on the form saying that this is for you.
And I know that there's a huge argument here for like fair use. Like if a professor gets it, can they make copies and put into their packet for their 50 students? I mean, all of us can sit here and say, yeah, they should be able to do it. They're technically not supposed to be able to do it. Yeah.
Okay, the library recently acquired some additional volumes of a journal to which it no longer subscribes. These volumes cover years missing from the library's holdings of this title and were obtained from a library that has merged with another library, meaning that at the time that they were acquired, a valid subscription was maintained. May the acquiring library use the donated volumes for interlibrary loan?
Ooh,
This is a fun one. Come on. I know at least one of you knows. Ken isn't allowed to answer last, but everybody else can.
Are we provoking the first sale a little bit here?
That's right.
Very
That's
good.
Yay, Christy gets an A.
Okay.
I'm telling her boss that she gets an A.
Okay, thank you.
Yes, because it's the first sale doctrine, and gift volumes count as first sale because somebody paid for them. I mean, it isn't any kind of IP theft or anything, or copyright theft. Correct.
Right. They didn't, make a copy and then give
Right.
us the copy and then
Exactly.
sell it to us or something.
Exactly.
Yeah.
Yeah.
I think this is the last one.
Yeah, that's the last
If
one.
a library is the only one in the region that has a license for a full text journal, what is the library's responsibility to fill the interlibrary loan request from that journal by making a copy for requesting libraries?
It depends.
What are some things it would have to consider first to do that? Maybe like the amount of requests that they get, maybe? That's one thing I think about.
Especially right now.
Especially right now.
With that, us being limited in the time that we are here, basically, as lenders, we're not obligated at all to fill anything.
Nope.
We do it because the more we lend, the more we have people who are willing to loan to us.
Now, somebody just said a thing about a license, but that is true. I can't sit there and tell, say, Lynn University, oh, absolutely, we'll fill it for you. And then turn around and tell FSU, well, no, we're not allowed to fill that. That's different.
Yeah.
But like Kim said, we are allowed. I mean, if we don't have time to do it, we can do, or if it's somebody who we don't have an agreement with. I mean, especially the last year, we haven't had any students until relatively recently. Emily could come back for a bit, and it's just been so tight. And then there's some places here, like say in Florida and other parts of the country, their ILL is one person. They do everything. Yeah. So, they don't lend very much. But yeah, so we try to be nice. We try to be as reciprocal and as collegial as we can be. Yeah. But we don't have to be. But we try to be. All right. And so that is it with the presentation. We are here to answer any questions. We might not be able to answer them all, but we'll do our best if you have any.
I have one.
Yes, sir.
From an operational standpoint, if different publishers have these different sorts of requirements as far as what can be done, with their stuff, how does the staff keep track of that and
Well,
filling requests?
there is licensing, and the way the Iliad is set up too, that kind of gives us an availability. When we go in to look at the holdings, it'll say what years are available. So that is the very easy answer. Sometimes we have to look at the licenses.
Okay,
Yeah.
thanks.
Every request we comes in is case by case basis,
Right, yeah.
borrowing and lend.
Because some of the embargoes are really weird, especially Taylor and Francis. They're horrible. It's just so weird. Sorry, I interrupted somebody.
So it sounds like, this is Christy, so it sounds like the licenses really do vary among publisher by embargo, or how long they have to wait until it can be released to more people, conditions, other things like that. It's all over the map, it sounds
exactly. And that is one good thing with Iliad, when Kim's talking about, there is actually a copyright clearance that everything goes into. Loans don't, like if you're just getting a book or something, and to an extent that gives us an awful lot of information, what it'll cost, who's the right holder, and even reciprocal agreements. So, that's very, very helpful. Some things we know will be fine. Some things we kind of have to, really kind of drill down and get more information.
But then there are times that, when they are putting a lot of requests in, we say, well, maybe we can get a loan of it.
Right.
That's much easier when it's a book. If it's a journal volume, it's usually someone that we try and find that we have a good relationship with. Again, that's why we lend a lot, and we're very generous lenders, is that we literally had them say, well, we don't usually loan this out. However, we're going to give it to you because you've been, really good for us. So that's why we try to build these relationships in order to get things for our patrons, because sometimes it's just, well, we can go ahead, get one of those articles or one of the chapters, and we'll try and get the book for you. That way we're avoiding the whole copyright thing, because we literally can't get what you are asking for.
We've even done that with some of that healthy trust books we're not able to lend out to our patrons. We're sitting there and say, we go ahead and put in a request for you. It's coming from North Carolina, but we can, go ahead and copy the first 2 or 3 chapters if you want. We've done that, and so sometimes they take us up on that, sometimes they don't.
How much does it cost for a request for, like, to get the copyright clearance for an article or for a book chapter?
It depends. Lots of times the book chapters you get for free. Kim and I would sit there and say, we have actually emailed book authors before, just so they send an email. Yeah, we don't care. Go ahead and do it. And we have so many agreements. We don't have to pay that often. But just like Kim said, the STEM things, they can be $100+ just for the copyright. Some of the humanities, it's like $1.75, $4. It just depends.
Yeah, each journal, each book, it's a different cost. So it is, like I said, it's a case by case basis. There is no real standard.
I mean, it's funny, like sometimes people will put in certain things like that are in public domain, like 100%, like say we need the first 3 chapters of Pride and Prejudice, and it's not a specific edition, like say like the Riverside or something, and we're sending the link to like Project Gutenberg or something. Sometimes it's really easy and it doesn't cost us anything.
And then I had another question about the fair use. What's your department's position on that?
Which part? Which specific part of it?
I mean, like in terms of requests.
Well, in terms of requests, we are right now, basically following Cantu for now. We do what we think is okay, and I'm not stonewalling. It's like if somebody wants us to, there's 15 chapters in a book, can you do 14? Yeah, we're not going to do that. It's not going to happen, and we're not going to even ask for that. But when people say, oh, well, you can't do more than 20% of the book, there's no law that says that. There's nothing, so we just kind of use our common sense right now, and that's what Kim and I said. Having all these different weird arrangements and not having it codified, you kind of have to just use your best judgment.
Well, it's things like the rare books, that it's literally only held by a couple libraries, and it's rare, it's in delicate condition, so we've had requests, come in from special collections, or that are in our special collections, and we're one of the only ones, or maybe the only one who holds it. And we can, say, no, this is a fair use case, and, we think that will be fine, and we are willing to, and we'll do that. But again, it's case by case.
And also that Facebook group, I mean, I keep on mentioning it, but people will ask questions like that in there, and people are really smart in there. They're come in and they're post case law and everything, and that helps too. That's a really good resource. I have to say, if it was something that was really sketchy, we would refer them over to legal, or we would check with somebody like that.
Okay, because I know that different places
Oh,
have
yeah,
different
yeah.
stances on fair use.
Yeah,
like,
we kind of don't
functions-
have any policy,
Mhm.
I mean, I'll be honest. I mean, because my personal opinion is everything like what we do should be fair use
Mhm.
within reason. Like I said, not copying a whole entire books published last year.
But our actual
but yeah.
practice is very conservative
Yeah.
in following Contu.
Exactly. For now.
Pretty,
For now.
yeah, pretty strictly, but
It was a little bit looser a year ago, I'll say.
yeah, but that's the thing is
Yeah.
that, since COVID, the number of ebook requests as a lender that have come in has skyrocketed. Like before, I always said, well, we can't loan ebooks. So if I get an ebook request, they made a mistake and they put it on the wrong record. They put it on the ebook record, not the hard copy record. But now, no, it's like even like notes in there. We want the ebook for our patron, and so that's kind of a new normal is that it's coming in. So things are changing because right now we don't have the means. Like there are some ebooks that we can download the whole thing as a PDF, but we can't loan that because that would not be covered, with the current copyright guidelines. But there are things like in the public library, they have overdrive. So that's where, it's limited access to that person and it goes away after it. But we don't, as our setup that we have now, we don't have that situation. But maybe in the future, there will be something for ILL that will allow us to temporarily loan ebook or temporarily give access to a streaming video to another institution. Because we do have that. We have borrowing requests where our faculty member or a student says, I see FSU has it. Can you get me access? And we have to tell them no.
Mhm.
Right now.
I mean, and if we contacted FSU, they wouldn't be able to do it either. So some people we've kind of tried it with each other and we're not able to do it. But like Kim said, I think things probably would have changed anyway. I think this past year are really going to change some things on the libraries and some other issues like this.
Kind of on a similarly related note, the Digital Millennium copyright has these exceptions that they pass every 3 years that allow libraries and educational institutions to do various things. Well, it's under review this year.
Right.
So I'll be talking about that in another upcoming masterclass series, but you all are welcome to give your input to those things to the Copyright Office if you want to give them.
We're not making any money from this. None of us are. We just want to help patrons. So that's why it's really frustrating when you have to tell people no. And, is there even a real reason to say no? Is it just more, like I said, of a convention and tradition more than anything? I guess we'll find out.
Yeah, that's like what the white paper was saying is that there is a limit of, there is an exemption because it's not supposed to be taking the place of a subscription or buying the book. There is a limit on how much you can fill. But the current standards of the Con2 and the 5 that legally right now we may have the complete right to fill more than what we are now without having to pay copyright, but that's not tested yet. And so that's probably going to be in the future, especially more libraries are looking at this and are changing is because they had to confront with COVID that they didn't have access to the hard book or they couldn't mail it, and they still wanted to and needed to provide access to these books and articles. So I think things.
And just remember, that is
in the next few years.
That is the crux of the Georgia case. They were just like, we're not going to do this anymore. So sue us, which is what happened. Yeah.
It almost touches on the controlled digital lending, that is, if the library has.
Exactly. I almost put some stuff about that in, and we're really not doing that yet. So I didn't want to open that all up, but yeah, right. Exactly.
So but that basically means if we have a hard copy that we can scan it and then loan it out to somebody.
Right. Correct.
Okay, just to say some things that in the chat, Pamela says, thanks for the presentation, the quiz, and that you two are good detectives.
It's true.
Yeah, Lori wanted to know if you keep documentation regarding fair use, and you said no, but that was an interesting idea. Yeah, that was, I kind of considered that myself. So I didn't know if anyone had any other questions they'd like to ask to the presenters. If not, I wanted to give a couple announcements. We're going to have another master class on Tuesday, April 21, called Copyright and Teaching, Classroom Exception, DMCA, and Teach Act. So we'll be talking about those just over a couple weeks from now. And then after that, following Tuesday on April 27, we'll have Copyright Matters, talking about images, tables, plagiarism, and infringement. Ken Frankel and Lori Rebar of Instruction Engagement Services will be co-presenting on these along with myself. So I wanted to give you that heads up, but I will send emails and calendar invites with that information so you could register. And it looks like Melanie said, please feel free to contact her or Kim with any questions.
Yeah. We do have some useful links that we slapped on the end of this PowerPoint. So the first one is basically a bunch of fair use cases that have gone that you might be interested into looking into and doing, some research. That's how we found some of the ones, and plus we just find it interesting. So
yeah, we like it. So
we like it, and then the actual copies of the
white paper,
DMCA. The link that we have on our webpage for Con2, specifically, it starts, at page 18, which is, what we use currently. And then the link to the white paper, so you can download and read it. It's pretty fast read, but it's very interesting.
Yeah. And thank you, everybody. Thanks for taking almost an hour and a half out of your day to come and listen to this. Just like Kim said, it's something we're very interested in. We know not everybody else might not be as interested as we are, but it's something very interesting, and I think things are going to change. So we're seeing. Yeah. Thanks again.
Well, thank you too for presenting with your updates and your knowledge. And we now know a little more to advise our faculty, instructors, and students with these requests too. So thank you. It's very, thank you.
Yes, for when they ask, why didn't you give this to me? I want it. Like, well, copyright.
Yes.
It's a thing.
All right. Well, I'm going to stop the recording now, but thank you everyone for your